Good morning, everyone. Welcome to the latest edition of the Shepherd Winterburn Rural Disputes Resolution Team's series of video webinars. My name is Hamish Lean. I'm Head of Property at Shepherd Winterburn, and I'm going to be speaking to you today about common problems that we've faced in relation to the Tenants Improvement Amnesty. I suppose I should start by saying that one of our biggest problems has thankfully gone away because the tenants' amnesty has been extended, as you probably know, until the 12th of December of this year, whereas previously the amnesty period was due to expire on the 12th of June. There's nothing like a deadline to focus clients' minds, and our experience was the closer that we got to the 12th of June, the greater the volume of inquiries we got about the Tenants Improvement Amnesty. And there was quite a lot of pressure to get notices served and agreements entered into before the amnesty period ran out. Thankfully, that pressure has been relieved. However, clients being clients, I suspect at the beginning of November this year, we might find ourselves in exactly the same boat. So, a good place to look when dealing with the Tenants Improvement Amnesty is the Tenant Farming Commissioner's website, available via the Scottish Land Commissioner's website. There's a lot of very useful information there about how to go about the Tenants Amnesty. And of course, Bob McIntosh, the Commissioner, has issued a code of practice with regard to implementing the amnesty, and he strongly recommends that tenants and landlords attempt to reach agreement about what should be in the amnesty. And of course, amnesty agreements are provided for in the Land Reform Scotland Act 2016, which is where you'll find the detailed rules about the amnesty. Unfortunately, however, our clients, those of whom are tenants, have found on occasion that it has been impossible to get their landlords to engage in the amnesty process. That's not to say that all landlords behave like that, and there are a number of landlords who have proactively approached their tenants about engaging in the amnesty. But unfortunately, there are a small number who just refuse to participate at all, and where it doesn't appear that there will be any sort of agreement possible. Tenants in that position are faced with very little choice other than to serve a formal amnesty notice. Now, there are certain technical requirements about the amnesty notice, and unfortunately we've seen a number of notices which don't appear to contain all of the technical requirements that the notice is supposed to, and we think that those notices are probably invalid. So what are the technical requirements of the notice? Apart from obvious things like detailing who the landlord and the tenant are and what the farm which is subject to the amnesty is, the notice must contain a complete list of the improvements that the tenants say should be included in the amnesty. It should also include details of the manner in which those improvements are carried out, and it must also contain a statement to the effect that it's fair and reasonable that the landlord pay compensation for that improvement at the end of the tenancy. It's enough to say that it's fair and reasonable that compensation be payable on the basis that the improvement is reasonably necessary for the efficient management of the holding as an agricultural unit. There needn't be a great deal of detail in respect of the manner in which the improvement was carried out, but there does need to be some level of detail there. So, having served the amnesty notice, a landlord then has a strict 2-month time limit within which to object to the notice. Often landlords will want to object simply to keep their options open, because failure to object will mean that all of the items in the amnesty notice then qualify for compensation when the tenancy comes to an end. The objection notice, however, also has technical requirements, and in fact there are only three grounds of objection that a landlord has in relation to an objection notice. The first, and it is admittedly quite a wide-ranging ground of objection, is that it's not fair and equitable that the tenant receive compensation for the particular improvement. The second ground of objection is that the landlord carried out the improvement in question or part of it. And that might be where somebody is claiming that the whole of an improvement belongs to the tenant in an amnesty notice, whereas the landlord knows that they contributed 40% of the cost, or whatever the case might be. The third ground of objection is that the tenant received some benefit from the landlord in return for carrying out the improvement. And the benefit might have been something like a reduction in rent for a fixed period of time, and so on. Now, once again, in the same way that an amnesty notice might be invalid if it's not technically correct, the objection notice must found on one of those three grounds of objection to be correct. And if it doesn't, then it in turn might be invalid. Now, that's all right if the landlord realises within the 2-month period that a mistake has been made and then has an opportunity to serve a corrected objection notice, that will be of no use to the landlord if the 2 months have come and gone. So, the landlord having served an objection notice, the ball is back in the tenant's court, because the tenant then has a 2-month period within which to make an application to the land court, seeking approval from the land court that the improvements in the amnesty notice are suitable and should be approved for compensation at the end of the tenancy. So, so far as notices are concerned, I don't really want to say much more than that. The next issue that I wanted to talk about is in relation to some of the objections that our clients have received, where they have tenants lodging amnesty notices or seeking to reach agreement with the landlord. Often, for one reason or another, the tenant is unable to produce any written evidence of having carried out the improvement. Now, that's perhaps not difficult to understand when a tenancy may have been within the same family for 2 or perhaps even 3 generations, and the improvements in the amnesty notice were referred to or carried out during the course of the last generation, or perhaps even the generation before that, and the paperwork has been lost in the midst of time. Now, the tenant may have a very strong belief that the improvement was carried out by a parent or grandparent. And they might have a good reason for that, of course. They might have been a child when the improvement was actually carried out and remember all about it. Or they may remember that they have always been told by parent or grandparent that, well, yes, we did that and the landlord didn't contribute. If the landlord has evidence, written evidence, to be able to rebut that, then that should probably be the end of the matter. But it's often the case that the landlord who is complaining that there is no written evidence that the tenant carried out the improvement themselves have no written evidence to the contrary. If the matter were ever to end up in the land court, then it's likely that the matter would come down to the credibility of the parties. If the tenant has a memory of the improvement being carried out when they were a child, or have been told by a parent or grandparent that something was a tenant's improvement, and the landlord has no evidence to produce against that, then there's no reason to think that the land court would refuse to accept that evidence on the part of the tenant, and the improvement will be approved. Another problem that we see tenants facing is that landlords and their agents will demand, before accepting that something be included in the amnesty schedule listing the improvements, a certificate, a building warrant, or planning permission, or an electrical certification of some sort. None of that is necessary for the purposes of the amnesty. What is relevant for the purposes of the amnesty is whether or not the improvement was carried out by the tenant. Questions of whether it was carried out with planning permission and there's a building warrant available and whether or not there's an up-to-date electrical certificate, those questions might all be relevant at the end of the tenancy when a valuer is assessing the amount of compensation, but they're not relevant with regard to whether or not it should be included in the amnesty agreement in the first place. Now, the measure of compensation for an improvement is the value of that particular improvement to a hypothetical incoming tenant. So one can readily see that those sort of questions might well have an impact on value, but they don't. Once again, I repeat, they don't form a reason for not including that item in the amnesty in the first place. So leaving aside issues of evidence, some of the other problems that we have to deal with in respect to the tenants' amnesty is the proper treatment of writing down agreements. Writing down agreements are agreements where the landlord and tenant agree that the compensation for a particular improvement will be written down to a nominal sum or perhaps even to zero over a fixed period of time. Now, writing down agreements as such were declared invalid by the 2003 Act in a way which meant that you could no longer enter into writing down agreements after the 2003 Act came into force on 28th of November of that year. That left a question mark over whether or not the Act had any effect on writing down agreements where the writing down period had expired before 28th November 2003, and those writing down agreements where the writing down period straddled the coming into force of the 2003 Act. Now, there is an exception to the general rule, which I'll discuss in a moment, but it's my view that if there is a writing down agreement in relation to a particular improvement, and the writing down period has expired before 28th November 2003, then that particular improvement will not qualify for compensation under the tenant's amnesty at the end of the tenancy. And in fact, the question of compensation will be dealt with by the writing down agreement and whatever it provides. Now, that's not to say that in an amnesty agreement, the amnesty schedule listing the improvements shouldn't include that particular improvement. It's simply that the schedule should detail that the compensation to be paid for it will be by reference to the particular writing down agreement. Remember that the amnesty schedule is useful not only for identifying items of improvements for compensation, but also to identify what represents the tenant's improvements. The tenant shouldn't be rented on the improvements, and the amnesty agreement can be a useful tool for future rent reviews. Writing down agreements relate to compensation, not to whether or not an improvement is subject to a rent review or not. That leaves open, of course, the question of writing down agreements that straddle 28th November 2003. There are two conflicting views, one of which is that the writing down agreement is binding on the parties. The other is that the effect of the 2003 Act is to make null and void the writing down agreement. It's a bit of a moot question. Interestingly, however, there's been no litigation directly focused on that question in the Land Court since the coming into force of the 2003 Act, and that might in fact indicate that the industry as a whole regards the question as settled, and that such writing down agreements are in fact fully enforceable. I suppose time will tell, and we'll have to wait and see if there is a definitive court opinion in due course. There is, however, one important exception where a writing down agreement will be undoubtedly invalid, regardless of whether or not writing down period has expired before or after the 28th of November 2003. That's because of the addition of Section 33A into the Agricultural Holdings Scotland Act 1991 by the 2003 Act. What Section 33A does is declare that if the tenant carried out an improvement which was actually supplying an item of fixed equipment that the landlord should have provided at the start of the tenancy in order to comply with the landlord's obligation to provide fixed equipment in a thorough state of repair that's suitable for the efficient management of the holding as an agricultural unit, then no agreement between the landlord and tenant, which means that the tenant will not be entitled to claim compensation for that improvement, is enforceable. And so one can imagine that a farm let out under a 1991 Act tenancy without any buildings, but which actually did require buildings in order to comply with the landlord's obligation to provide fixed equipment at the start of the tenancy, and the tenant then went on and built at his own expense the necessary building or buildings. A writing down agreement which said that compensation was going to be reduced to nil over a fixed period of time would not be enforceable. And that's regardless of whether or not the writing down period expired before or after the coming into force of the 2003 Act. Once again, the question would be whether or not you actually need to include an improvement like that in an amnesty agreement, because the provisions about compensation are completely independent of the tenant's amnesty itself. However, the amnesty agreement can be a useful catch-all agreement simply to identify the status of all of the fixed equipment on the unit, and it might well be useful if the parties agree to record Section 33A type improvements in the amnesty agreement as well. Another problem area is the correct treatment of post-lease agreements. Now, although every post-lease agreement has to be read carefully for its precise contractual provisions, generally speaking, the impact of a post-lease agreement is to transfer not only the repairing obligations in relation to fixed equipment, which a tenant has anyway in terms of an agricultural tenancy, but also to transfer to them, in relation to a 1991 Act tenancy, the landlord's renewal and replacement obligations for fixed equipment that have worn out through fair wear and tear, so that the tenant becomes responsible for that renewing and replacement obligation. Now, post-lease agreements are perfectly valid, and work done because the tenant is obliged to under a post-lease agreement will not be an improvement that is capable of being included in the tenant's amnesty unless the work that the tenant carried out includes a significant element of betterment as compared to the fixed equipment that was being replaced or renewed. It's better understanding that concept by examples. For example, replacing the windows in the farmhouse and replacing single glazed windows with modern double glazed units. That's not a simple act of replacement and renewal. There is a significant element of betterment there, obviously enough, between a double glazed unit and a single glazed window. Likewise, replacing and renewing an old tile drainage scheme with a modern drainage system involves a significant amount of betterment. Demolishing an old-fashioned traditional steading and replacing it with a modern general-purpose agricultural building will also, without doubt, involve a substantial amount of betterment over and above the strict requirements of the post-lease agreement. That element of betterment should be identified and it should be included in the amnesty agreement or the amnesty notice as appropriate. So these are bite-sized video webinars. That was a fairly rapid dash through some of the issues that we face with the Tenants Improvement Amnesty. There will be a link, or there should be a link in front of you just now, to my script for this webinar. Please feel free to download that. If you do have any questions in relation to the Tenants Amnesty in general, please don't hesitate to contact me. And I'd just like to say thank you for listening. I'd also like to recommend the next edition of the Dispute Resolution Team's webinars, when Elaine Brailsford will have a quick paddle into the murky waters of legal riparian rights. So hopefully you'll be able to join us for that. Thank you for listening, and goodbye.